Senate Bill 414 is the bill that is probably going to have the most impact on how we all function within court, and therefore it's going to have impact on casework practice. Senate Bill 414, as I said in my introduction, comes from the advocates. And largely, Senate Bill 414 is designed to emphasize the sort of well-being kind of stuff that we're trying to do with the families in our system. And Senate Bill 414 has to do with placing siblings, trying to place them together, placing children with relatives. It has to do with casework regarding education progress and regarding contact with the children and families in the system. There's also a piece of this that has to do with legal orphans. And we're going to go through this probably a little more quickly than we should, but we have time constraints here. Let's start down about halfway on page 6 with a definition of sibling, because this is very important. If we're going to talk about sibling placement and placing siblings together. A sibling is, first of all, a child who shares parents with another child. Okay, my wife and I have 2 children; they are siblings. All right. If we adopted a third child, then that child would become a sibling of the other 2 because they are siblings by adoption. If you have someone who is unmarried and has a child, and someone else who's unmarried and has a child, and they get married and they move in and they blend their children into a family, those are siblings because they are step-siblings by virtue of the marriage of their parents. They become siblings by definition in this statute. If you have single people who move in together, do not get married, blend their children together, those are not siblings for the purpose of the statute. Okay? Don't ask me why, but they're not. Does that mean that we are not going to try to do placing those siblings together as we would if their parents were married? It doesn't necessarily mean that at all. But nonetheless, they are not, strictly speaking, within the ambit of the definition of siblings. Section 4 at the bottom of page 6 is the first place that we run into this duty. It's an ongoing duty throughout the life of the case, and it's really 2 duties. The agency has a duty to do diligent efforts to place children with relatives, and a duty to do diligent efforts to place siblings together when they're placed in substitute care. Now, included within relatives, within the definition of relatives, is a person who has what we used to call a psychological parent relationship with a child, what we now call a caretaker relationship. This kind of close relationship between a child and someone who is not actually their parent, such that this child looks to that person for the kinds of things they would look to a parent for, psychological support and meeting their physical needs and things like that. So whenever I talk about relative, I'm also talking about people who meet the definition under 419B116 of a caretaker. All right, diligent efforts. Diligent. This is a word that we haven't run into before in child welfare cases, and it is not defined in the statute. Okay, it is not defined. And there was talk about defining diligent, but the advocates for this bill said, and the legislature agreed with them, that there was really no reason to define diligent. They did say, to give us kind of some clues about what diligent might mean, they said, go look in Merriam-Webster. Look in the dictionary under diligent, and you'll get a good idea of what it means. And I've looked at that, and I think that's not a bad idea to look at that definition there. Do not go to a law dictionary. Don't do it. If you go to a Ballantyne's or a Black's, you're going to get sucked into due diligence, and lawyers in the room can tell you that due diligence, depending on the context you use that phrase, it's everything from the least amount of effort you could possibly make all the way up to having a fiduciary duty for something. So don't look at a law dictionary, but Merriam-Webster is good. The other thing they said was, look, diligent efforts is somewhere more than reasonable efforts, but less than active efforts. More than reasonable, less than active. Got it?
Sure.
To me, that's a little bit like saying, well, I'll tell you about this place. I'll tell you about this place. This place is somewhere between Middle Earth and Narnia. Got the coordinates on the map? Okay. But all kidding aside, diligent efforts, we've been working with reasonable efforts and active efforts for a long, long time. There are no definitions of those words in any statutes, and we have worked out individually, as a community, within the different courts and such, we've worked out what we mean by diligent efforts. And I think that's the process that we're going to go through, so that we'll be able to tell what diligent efforts are. At least the judge will be able to tell what diligent efforts are. So diligent efforts to place children together, diligent efforts to place with relatives. And the agency will provide at every hearing information to the court from which the court can make this finding about whether there's been diligent efforts made or not. Diligent. And this finding is made at each and every hearing through the process, the shelter hearing, dispositional, the review, the permanency hearing, until such time as the court excuses the agency from continuing that duty. When would the court excuse the agency from continuing that duty? When you get the siblings placed together. Got siblings placed together? Solid. You don't have to do it anymore. Okay? You have exhausted all the relatives and none of the relatives fit as a relative placement. Persuade the judge that you have exhausted all those and that you've done the thing that you're supposed to do, and the judge has the ability to excuse you from that particular duty. Now, supposing that you are excused from the duty to place with relatives, and all of a sudden on the horizon, Uncle Sid shows up, a brand new relative. Then the duty is going to be reinstated until you deal with whether or not to place with Uncle Sid. So it's diligent efforts to place with relatives. Yes?
Does DHS have to present evidence that they've done a diligent relative search?
Yes, yes. Diligent efforts to place with a relative would include using diligence to identify relatives. Yes, it definitely would. Yes.
Which trumps relatives or siblings?
Neither.
Well, grandma's willing to take the 10-year-old, but not the baby.
Well, let's talk about that because one aspect of placing with relatives is how are you going to, supposing you get all relatives identified, how are you going to choose among them, or how are you going to decide that any of them is necessarily a good fit for placement here? 419B 192 has always provided that the agency has a duty to make reasonable efforts to place with relatives. Okay? And that reasonable has now been replaced with diligent. Okay? So it's the same as it's always been. And there are 4 factors there that you use in determining whether or not to place with a particular relative. And I'm not going to go through those 4 factors, but there are things like, they can keep the child safe, they can support the casework plan, those kinds of things. If grandma can't believe that her son possibly could have done those nasty things to his daughter, then probably we're not going to place that daughter with grandma because grandma's going to have a problem protecting the child. Okay? So, 4 factors. But now another factor has been added, so there's 5. And the 5th factor is, can this relative or this person with a caretaker relationship, can they take all of the siblings that need to be placed in foster care? None of these 5 factors trumps any other. They are considered in making the decision. None of them has priority. And also other factors can be considered. The list has always said, consider this list, including but not limited to these things, is what it said. The agency will consider, but not exclusive of these things. If I'm a person for the agency and I'm going to the judge and I'm trying to say I made diligent efforts to place with these relatives and I can't place, or I want to place with this one, I'm thinking that you may well want to use the language of those factors. Say, according to factor 1, this is a good candidate. According to factor 2, we have problems. That kind of thing like that. But there is no black and white answer. If you have two relatives, both of whom, all things considered equal, are equal, and one of them can take 2 of the kids, and the other can only take 1, the one that can take 2 should probably win, if all other things are equal, because they can take 2, and that's one of the factors on this. But don't get hung up on this, make this a cookie cutter kind of thing, because all of those factors have to be weighed together. Okay? So that's how you determine the priority. And again, it's not anything hard and fast. Yes?
I have a
question about the caretaker relationship to a child, and not to split hairs, but I was wondering in the other law or the other statute where you now have to report if that child is with a relative, one of the statistics, where would that be? If that caretaker relationship could be a godparent, could be a daycare provider, could be a teacher, where maybe you're making more than community placements, but really connected placements, but they're not family. I'm just wondering, how would the agency use that? How does that person fit into that other statistic when you're really trying to figure out whether you're doing a good job placing kids who have attachments to other people?
And this is a really interesting question that I don't know the answer to, because the data indicators, definitions of the data indicators, I don't know that, and I think you're going to need to ask.
Because I think about how often we do child-specific certification,
I understand,
which shows the attachment, but they are not relatives.
No, I understand, and it's important for federal reporting and stuff. So you want to ask around your shop and find out what the people like Maria Duryea say about that in terms of the federal definitions. Because I know we're trying to line all the federal definitions up. For example, the definition of termination of parental rights according to the federal government includes relinquishments. It does not just include court cases that terminate parental rights. So it's important, but I don't know what the answer to that is. The next piece of Senate Bill 414 that I want to talk about is Section 8, and this is the one that's going to be of the most interest to caseworkers. Because now your paperwork to the court, your 333, your 310, and all those things, those are all being modified so that you're going to be providing some more information to the court. And this information is going to be in the form of some lists. The first list has to do with the education of the child. Your paperwork is going to have a list of all of the educational placements the child has had since the child came into care, as well as the periods of time that the child attended that school. Okay? All of the schools attended and the period of time that they've attended. The question has been asked, is this retroactive? Kids been in foster care or permanent foster care for 6 years. Do we have to go clear back like that? What I have learned is that the computer system is being fixed so that information, insofar as that information is recorded back that far, that information will be there. Yes.
Does that include going back to early Head Start and Head Start programs?
If the child was in foster care, probably yes. Probably yes. Okay. Why do they want this information? The legislature wants the judge to be able to look at this list and see what the continuity of the child's educational experience is. If Crystal's been in 4 schools in the past 3 months, the judge is prompted to say, what's going on here? Okay? There may be a perfectly good reason why Crystal's been in that many schools in that period of time, but we want the judge to be able to look at that and know and find out what that information is. So that's what's going on there. The other thing that's on this list is if the kid is over 14, how many credits does this kid have toward high school diploma? High school diploma. Not a GED, nothing else, but a high school diploma. What's behind that? The legislature knows, just like we know, that the kid who has a high school diploma, statistically speaking, has a better chance for better outcomes than a kid who has a GED. Does this mean they're requiring every kid to get a high school diploma? No. What they're doing is they're saying they want to call attention to the fact that we want to make efforts to do everything we can to encourage kids to get a high school diploma. Okay, I know, and you know, that 14, 15, 16, 17-year-old kids know everything. Okay? And when you go in and try to do your transition plan that you're supposed to do with kids that age, their transition plan to adulthood, very often they're going to say, nope, got it all figured out. Thank you very much. Don't need your help. I'm going to leave here and I'm going to become a roadie for the Red Hot Chili Peppers. So leave me alone. How much effort do you have to make in that particular case with that particular kid? And the answer to that is, the best answer I've heard is from a judge over on the coast, who shall remain nameless, but her name is Paula Brownhill. And what Judge Brownhill says is, I know you can lead a horse to water, but you can't make him drink. She said, that's great. You got one of those horses? Bring it into my courtroom. Put it in front of me. I want to see the water dripping off the muzzle. Shove the head down into the trough, and they still refuse to drink. Okay? So you're not responsible for the outcome that they're going to get a high school diploma. but the court is going to want to know what the credit situation is. Okay, now, question.
Backing up to the list of schools, I'm a little bit confused about why we're providing lists. Because for me, I'm having my cases reviewed like every 90 days, and I'm consistently providing information about schools. Do you have a little more information about why we're being required to do this?
Because the legislature wants the court to see a history, a trend, what's happened with this kid since this kid came into care. I might see that a kid for the past 3 months has been in the same school. Good, that's good to know. But I also am going to want to know that maybe there were 4 or 5 listings in the previous 90 days. It's to have an entire look. And the other thing is, supposing that's reversed. Supposing the kids had 3 school placements in the past 90 days, but for 2 years in care before that they had 1. Okay? That puts you in a better position to persuade me that there's an anomalous thing going on here and we're working on it, but by and large the kid is in a good condition.
This should already be happening.
I'm sorry?
This is already happening.
Well, it certainly should be, but it's not happening consistently. So, and the 310, all that health and education stuff, it's not happening consistently, and the legislature wants it to happen consistently. And if you're already doing it, then you're ahead of the game. You're ahead of the game. The second list has to do with face-to-face contacts between the assigned caseworker and the child. Face-to-face contacts between the assigned caseworker and the child. The assigned caseworker. Okay. Why the assigned caseworker? Because the legislature believes that the person in the system who is primarily responsible for the well-being of the child should be the person who is seeing the child most often. Does it mean that every visit has to be with the assigned caseworker? No, it doesn't mean that. But it also means that if the court sees that there were 8 face-to-faces and they were with 8 different people, the legislature would like the court to ask, why was it 8 different people? Okay? Doesn't mean you can't take a parental leave or something like that, but it does mean that the court is going to be looking to see that the person primarily responsible for the child's well-being in the system is the person who's making the face-to-face contacts. The other thing is they want to know where these contacts are occurring. Where are these contacts occurring? Okay? Because they have heard stories. Okay? It's amazing how much legislation gets passed because people have heard stories. Okay? They have heard stories where caseworkers will go to a school and sit in a little room, and they'll have 3 kids on their caseload, and they'll line them up outside and bring them in and see each one of them for 10 minutes, and then they've had a face-to-face with kids. Okay? Now, I don't know how true that is, but that's what they've heard. So what the legislature wants is the legislature would like to see part of the time that in this list of face-to-faces, it says that the assigned caseworker was in the foster home with the child. Okay? Because we all know what you can learn in the foster home, right? That you can't learn at school. Now, does this mean that the legislature says that you have to meet the kid in foster care? No. There are perfectly good, sound casework, social work reasons to not visit the kid in the foster home sometimes. But the foster home visitation, we want that to be a basic part of the visitation scheme. So, because the foster parent knows, well, you know what I'm talking about. So, the list of face-to-faces with assigned caseworkers and the location. And the third list has to do with visits. How many visits between the parent and the child? How many visits between the siblings if they're not placed together? Okay? The dates of these visitations. How many of them? Okay. And last in the paperwork, there needs to be a copy of the visitation plan. The visitation. What is the visitation plan? They want to make sure that's in there, and I know it's mostly in there now, but they want to make sure that that's in there. And if there's any talk or anything in the works about changing the visitation plan, that needs to be in there too. The legislature is very concerned about visitation. Okay, so that's Section 8, and that's the casework. That's the information now that's going to come to the judge. What's the judge going to do with this information? What does a judge do with any information? They make findings. Okay, they're going to make findings of fact. And the first, in Section 9, the first finding of fact the court is going to make is that these things happened the way that the paperwork says they happened. Very easy. These were the visits, these were the school placements, et cetera, et cetera, et cetera. It's going to be very easy. Now, it may be that somehow somebody's missed a visit and somebody will say, well, there was really a visit on this date that's not down here. Okay, good. We'll add that and then we'll make the finding. The next piece is going to be more difficult because the court needs to find whether or not what's recorded in terms of school and visits and all this stuff, whether or not this is all in the child's best interest. whether it's all in the child's best interest. So there's now going to be these best interest findings that are made at review hearings. And here's sort of the hard part about this. The court is supposed to make a determination about whether this is in the best interest of the child, and there is no consideration made in making that finding about the resources available to the agency to do it. Okay? No consideration of resources, just is it in the best interest? Okay? Now, let me give you an example, extreme example of what this is going to look like. I'm the parent's lawyer, and I'm in a review hearing, and I call to the witness stand Dr. Simmons. And Dr. Simmons is Crystal's therapist. Okay? Dr. Simmons. So I qualify Dr. Simmons as an expert, and then I say, you know Crystal? And she says, yes, I do. And I say, you're familiar with Crystal's diagnosis, prognosis, and halitosis? And she says, yes, I am. I say, okay, and you know about Mom, right? Oh, yes. And you've looked at Mom's psychological circumstances in the situation and blah, blah, blah. Yes, I do. And you heard the agency say earlier that Crystal gets 1 hour visitation a week with her mom at DHS. Yes, I heard that. Tell me, doctor, in your opinion, is 1 hour a week at DHS, is that visitation in Crystal's best interest? And Dr. Simmons says, no. And I said, oh, well, tell me, doctor, what would be in Crystal's best interest in terms of visitation? Well, Crystal's best interest in terms of visitation would be 5 hours a day, therapeutic visitation, weekends in a proctor situation, and 2 months on the French Riviera every year with the putative father. And I, as the parent's attorney, says, no further questions. You're the agency. You stand up and say, we can't do that. Granted, that would be good, but we can't do that. The evidence in the record is that the visitation of 1 hour a week at DHS is not in the child's best interest. Okay. Now, what does that mean? Supposing the judge does that, says, not in the child's best interest. What does that mean? Do you know what the penalty is for getting a not in the best interest finding? Nothing. It's the same as a no diligent efforts finding. Nothing. Does it mean the court won't say, I want you to do this, that, and the other thing because of this finding? No, it doesn't mean that, because the court, can make orders about that kind of stuff. But these findings, diligent efforts and best interest findings, have no implication in the calculus of determining reasonable or active efforts. They are totally separate. And here's why. Except maybe in some attenuated case, in an alternative universe out there, maybe it might be relevant in some small number of cases. And here's why. What are the reasonable and active efforts findings? The reasonable and active efforts findings are, first of all, to prevent removal from the home. Okay? Well, does the number of school placements that Johnny has had in the past month or 2 months have anything to do with removal of the child from home? No, it doesn't. Does placing Johnny and Crystal together in foster care have anything to do with removing or not the child from the home? No, and it has nothing to do with returning the child to the home. Okay? Reasonable efforts and active efforts findings are based on what will lead to reunification, and if you're not doing something that would lead to reunification, you're not in danger. Okay? If you don't get the kid's teeth fixed, that's bad. We should do something about it, but it's not part of the reasonable efforts calculus, because bad teeth or not, Crystal can go home or not based on her teeth at all. Okay? Now, the third reasonable efforts finding has to do with implementing the permanent plan. We've now given up on return home, and now the plan is to implement the permanent plan. The permanent plan is a guardianship. Okay. Now, placement with a relative might implicate reasonable efforts because that relative is the guardian. Okay? And if you're not making reasonable efforts to place with the guardian, then you may have a reasonable efforts problem. That's not because it's a placement with a relative, it's because it's a placement with a guardian. You see, if you look at the best interest findings and the diligent efforts findings, they don't have anything to do with return home. But I hear at least one lawyer in the room who's going, wait a minute. I know, because I read a study, that the more visitation there is in a case, the more likely it is that there's going to be reunification. So if the agency's not doing visitation, it seems to me that's not only a best interest finding, it seems to me like that's a no reasonable efforts finding. Because if they gave more visitation, they'd be able to return the kid home. The only thing wrong with that is it's based on a logical fallacy. Those studies show association between visitation and reunification, but not a cause-effect relationship. Those parents who have the most visitation and have the best chance of reunification may well be getting that reunification for the same reason they had the visitation. They were dogged, they were determined, they tried to get more visitation, and that kind of behavior is generalized in their pattern of behavior of working their service agreement and giving their kid back. If you gave more visitation to every parent in the system, you can't show in any way that that would lead to more reunification. Okay? So until somebody establishes a link between the cause and effect link between visitation and reunification, you're not going to be able to bleed this finding over into the reasonable efforts finding. Now, does that mean lawyers won't try to do this? No, it doesn't mean we lawyers won't try to do this. We lawyers try to get every edge we can, and we try to argue these kind of things. At a permanency hearing, I can say, Judge, I don't know how you can even think of giving up on my client and going on to adoption. Look at all of the no diligent efforts findings that were in this case, that the agency didn't place those siblings together. And the judge is going to go, what are you talking about? Your client's progress toward getting her act together is not impacted one way or another by whether or not the kids are placed together in foster care. Nor were they impacted by whether or not we got the kid placed with a relative. Nice try, but no cigar. But don't think that lawyers won't try to do this but as I say, that case like where you're trying to effectuate a new permanent plan and the permanent plan is to place with Uncle Sid, if there's no diligent efforts findings in terms of placing the kid with Uncle Sid, then it's not really a diligent efforts finding, it's a reasonable efforts finding around that point. You see the distinction? Yes?
So, has anybody figured out how many hours this is going to add to permanency and review? And what's going to be the Eastwooders asked for attorney to represent them when they're right in the middle of arguing diligent efforts versus reasonable?
Well, I would never answer that second question, because if I ever gave legal advice to somebody in the agency, I would get a nasty phone call from Linda, something about interfering with a lawyer-client. I don't know what she's talking about, but I just know better than to do it, okay? The other thing about, did anybody sit down and talk about how much time this would take? Yes, people sat down and talked about how much time this would take. Nikki could explain to you why there was no fiscal impact. It has something to do with it didn't increase the number of cases, right?
Yeah, there's not a caseload increase, there's a workload increase. And Legislative Fiscal Office decided that would not garner any additional funds for the agency.
How about legally attorneys?
Well,
we actually, OJD did look at fiscal.
Yeah, we looked at a fiscal on this, and the reason that we modified our fiscal downward was because this is a lot less than the original bill asked for. Okay, and we don't think that you're going to get a lot of litigation around these things in most cases. Okay, we know that there are lawyers who are going to try this out, but we think in the end, the history of this is this. Something like this passes. What happens is everybody runs around with it for a while. Oh, we can do this, we can try that, we can do the other thing, we can blah, 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 blah. Well, the number of 5-day permanency hearings has dropped markedly since we started having permanency hearings. We had some, but it's dropped markedly. People figure out how to do this and what to do and what's going to work and what's not going to work, and then it goes away. I don't have any doubt that there's going to be more work involved in these cases, because these findings are designed by the people who passed this bill, got this bill passed, to get lawyers to talk about this stuff more in court. And don't fool yourself, there is a very definite push on the part of these lawyers for more visitation. Okay? And what we're talking to the judges about is saying, you do what you want, you're the judge, you're a locally elected public official, we can't tell you what to do. But you know from working in your communities what the limitations are in terms of resources, okay? And you can't order more money, right? Because you don't make laws and you don't make budget appropriations. So one of the things that you can do is you can say to the people who are in front of you, look, we need more visitation. So all you people who are parties to this case, put your head together. How can we imaginatively, innovatively, thinking out of the box, all this collaborative stuff, how can we devise more visitation in this particular case? And my former identity as a CASA makes it necessary for me to say at this point, one of the ways we do this is not to try to get the CASA to supervise visitation or to transport for visitation, okay? So that's a non-starter. But we as the people who are involved in these cases, the parties involved in these cases, we need to sit down together and try to work out ways to have more visitation. Okay, are there relatives? However it works. Okay, but that's the bad and the good about Senate Bill 414. I will entertain questions, but not comments. Okay? Sure, absolutely. You can even ask a question.
Timothy, tell me, in response to, did anybody look at whether this was going to increase time? And of course, we had attorneys that were advising DHS, looking at whether this was going to be an impact sufficient to warrant some kind of a fiscal impact designation for the bill. I guess I want to be clear that it's a little hard to say, well, we don't want to tell the courts how many schools kids have attended or how often we've had face-to-face or how many visits they've had with parents or their siblings, because it's a lot of work. I mean, those are really important. That's really important information for the court and the other people involved in the case to have, because it's about the kids that are within the court's jurisdiction. So to come forward and say, you might want all that, but it's just going to be too much work, is not it's a tenuous position to assert. I've heard from at least a couple of DHS folks that they are working on a way that the information required by this bill can be automatically added to the report. So just like face-to-face visits are now somehow magically, and this is a computer term, sucked into the report, so you can report on those, some of the information that's required in this bill will similarly get sucked into the report somehow, so that it's not the individual worker going through volumes and volumes going, oh yeah, they were at Cleveland High School for a week and a half, and then they went to Lincoln High School for 3 weeks, and whatever the list is, that some of that information will be automatically transported in. So there was a lot of talk about what the impact of this bill would be, and I think DHS is trying to work on minimizing the workload that it might create for the workers who are having to create these reports. And Catherine Stelzer here.
I can add one other thing too. We're trying to make it as easy for you guys as possible. There will be some extra pieces, but the other thing is we're working really hard with the Department of Ed in order to make sure that we can access that information, and they know that this is law, and so we're working on some letters, and they're going to be talking to their folks. So we should have an information sharing process.
And as I said earlier about new legislative requirements and things like that, if you're going into a hearing and early on in this thing, and all this information is not in your court report, I doubt seriously the judge is going to drop a safe on your head.